Welcome to episode 8 of Plaintiff Prep. At this point, your attorney has filed your lawsuit and the parties have probably engaged in discovery. Now, the parties are interested in discussing a potential settlement before going to trial. The point of this video is to help you understand the mediation process, which is the most common form of dispute resolution in Florida. So let's jump right into it.
At some point, you and your lawyer may agree to try to settle your case through negotiation after the lawsuit is filed. This is where mediation comes into play. Mediation is a negotiation in which a third-party facilitator or mediator assists all sides of the lawsuit in reaching a compromise settlement. Think of mediation as a formal conference where the parties to a lawsuit get together and try to settle the case without having to continue through litigation or going to trial. While mediation is not technically mandatory in Florida civil cases, most personal injury cases will be subject to mediation or arbitration at some point during the litigation process.
Mediation can be extremely helpful to all parties for a variety of reasons. For example, mediations can save time, stress, and money. Since mediation is basically just a discussion between the parties, it can also be quite easy compared to the formal trial process. Additionally, unlike trials and court hearings, which are held in public courtrooms, mediations are private and, with few exceptions, confidential. Mediations can also help the other side to better understand your case. In other words, if the defense has been unwilling or unable to understand your side of the story, mediation is great because the defense is forced to listen to you via the mediator. Thus, mediation may be all that is necessary to push the defense over the edge and offer you a reasonable settlement. Mediation also provides the parties with a bit of flexibility. Although parties typically settle the entire case, parties may choose to resolve specific issues or claims. That way, if the case proceeds to trial, less issues will need to be tried in court, saving the parties time and money. Finally, if a settlement is reached, mediations provide finality because the mediation settlement agreement is an enforceable and legally binding contract.
Let's talk a little bit about the mediation process. Generally, mediation begins with an introduction by the mediator, an opening statement from the plaintiff's attorney, and an opening statement from the defense attorney. After each side presents their opening, the parties will caucus, which is where each party goes into a separate and private room, and the opposing sides will only communicate with each other through the mediator. If the mediation is conducted in person, the mediator will go back and forth between the plaintiff's room and the defendant's room, trying to help the parties to reach a settlement.
Let's talk about who attends mediation. In personal injury cases, you will attend the mediation with your lawyer. The defendant's attorney and a representative from its insurance company will also attend. Sometimes the defendant will even attend mediation. At mediation, there will always be a mediator. The mediator is a neutral third party who both sides designated to act as an intermediary and help the parties reach a settlement. The mediator is not allowed to decide who is right or wrong or to tell you how to resolve your case. The mediator is simply there to help the parties settle.
Typically, if the mediation is conducted in person, the parties will be present together in a conference room at the mediator's office. The mediator will introduce himself or herself to the parties and the attorneys. Then, the plaintiff and defense attorneys will typically give an opening statement. The plaintiff's attorney will go first, and then the defense's attorney. The plaintiff's attorney will attempt to highlight the accident in question, present liability arguments, and list the plaintiff's damages. The defense attorney will then highlight the facts he or she finds relevant and present arguments regarding liability and the plaintiff's damages. It is important to note that opening statements are not required at mediation, and sometimes the parties will agree to waive opening statements. In these situations, the parties will jump right into caucus after the mediator's introduction.
Now, let's talk about the Mediation Caucus. A caucus is where the mediator meets privately with the plaintiff side and then the defense. During this time, whatever you and your attorney say to the mediator is kept confidential, unless you specifically request that the mediator relay a message to the other party. Usually, during the caucus, the mediator will meet with the plaintiff's side first. The mediator will ask for the plaintiff's opening demand for settlement. Then the mediator will bring the plaintiff's settlement demand to the defense. Usually, the defense will then make a counteroffer, and the mediator will bring that counteroffer back to the plaintiff's room. This process will continue until the parties reach an agreement or impasse.
So, how do the parties reach an agreement at mediation? Typically, during caucus, the plaintiff will begin with its highest settlement demand, and the defendant will begin with its lowest offer. Then, the parties will gradually work towards the middle as the mediation progresses. While the mediator cannot tell a plaintiff what to do, they can give guidance to help facilitate an agreement. If settlement is reached during mediation, the parties and their lawyers will be required to sign a mediation agreement.
So what happens if the parties can't agree? If the parties are unable to reach an agreement at mediation, the mediator will either declare an impasse or postpone the mediation to another day. An impasse occurs when the parties cannot reach an agreement and do not want to continue discussing potential resolution of the case. If the mediator declares an impasse, then the case will proceed towards trial.
Thank you so much for joining us for episode 8 of Plaintiff Prep. Please join us for our next episode where we will talk exclusively about the ways you can settle a case.